Hello everyone. The topic today we will cover is from Jurisprudence. Property, meaning kinds, modes of acquisition of property. So which is coming under Unit 4 of our syllabus, and the subject is Jurisprudence. So in this lecture we will cover property, meaning and its kinds. Okay? Property, meaning and its kinds. And in the next lecture we will cover modes of acquisition of property. So, property. The concept of property, it occupies an important place in human life. There is no doubt regarding this because it is virtually impossible. It is virtually impossible to live without the use of material objects, which constitute the subject matter of property, or nowadays we can say one of the subject matters of property. Now, in its widest sense, all animate or inanimate things belonging to a person are included within the meaning of the term property. Like, let's say, for instance, a person's life, a person's liberty and estate. These things may also be considered as that person's property. However, nowadays it has totally become redundant to interpret the term property in such a comprehensive sense. Now, as we know, Salmond, he was a very an eminent jurist. So, Salmond, while defining the term property, he observed that the term might be understood in one of the three senses, okay, or in one of the 3 points that we will discuss. What are those points? What are those senses according to Salmond? The first point is the term property. The term property, it includes all the legal rights of a person. It is including all the legal rights of a person. That is to say, it includes complete ownership. Or we can say the term includes absolute ownership of a man on material as well as incorporeal things. Now, material things are those things which are visible, which are tangible in nature. And incorporeal things are those things which are intangible in nature. Okay, like for example, the intellectual properties, various intellectual properties, like for example, copyright, trademark, the patent. These things are coming under incorporeal things. And the second point or second sense that he discussed is that the term property, it includes not a man's personal rights. The term property, it includes not a man's personal rights, but only his proprietary rights. Now, you may say, what do we mean by proprietary rights or personal rights? Now, proprietary rights are rights in relation to one's property. Proprietary rights are rights in relation to one's property, like which consist of things, assets belonging in possession, and ownership rights of a person or entity. And the personal rights are relating to the body of the concerned person, which may affect, let's say, his or her character, liberty, status in the society. Okay, so according to the second point, as per the definition given by Salmond, the term property, it includes not a man's personal rights but only his proprietary rights. Okay, now the third point he discussed, which Salmond discussed, is that the term property, it includes the rights of ownership. The rights of ownership in material things such as building, etc. Okay, and then comes Bentham. Now, he was another eminent jurist. Okay, Bentham. Now, according to Bentham, the term property, it includes ownership of material objects only. According to Bentham, the term property, it includes ownership of material objects only. Now, we can say that Bentham interpreted the term property in a very narrow sense. And then comes Austin. According to Austin, property denotes the greatest right of enjoyment known to the law, including servitudes. Now, servitudes means the meaning of servitude is that the state of being a slave or completely subject to someone more powerful. Okay. Now, according to Salmond, according to Austin, property denotes the greatest right of enjoyment known to the law, including servitudes. Okay. Then according to Austin, as we have already discussed, he discussed that the term property is sometimes used to denote the greatest right of enjoyment known as to law. Now, according to Austin, even servitudes are described as property in the sense that there is a legal title to them. Now, sometimes property means the whole of the assets of a man, including both the right in rem, that is the right against the whole world, and right in personam, right against a person. Okay. So, these are some of the definitions of property which were given by Salmond, Bentham, and Austin. Okay. Now, let us come to the next part of the lecture. As far as interpretation of the word property by the Honorable Supreme Court of India is concerned, the Honorable Supreme Court of India, in its landmark judgment, R.C. Cooper versus Union of India. The citation is AIR 1970 SC 564. Now, in this particular judgment, Honorable Supreme Court interpreted the concept of property in the legal regime. Okay. Interpreted the concept of property in the legal regime. And the Honorable Supreme Court in this case observed that the term property, it includes both corporeal things such as land, furniture, and incorporeal things like copyrights and patents. And now the recent trend of the apex court, however, it has changed. Court has started viewing property in the light of Article 21 of the Indian Constitution, which is one of the fundamental rights. Okay. Now, this is the modern judicial trend to interpret right to property in the light of Article 21 of the Indian Constitution, which is dealing with personal liberty. And it also deserves mention in this particular lecture. Now, the apex court, in a number of cases, the Honorable Supreme Court has expressed a view that Article 21 in its widest magnitude, it covers a variety of rights. Okay, or we can say it covers a variety of rights, including right to property. Right to property is also included. So, which constitute the personal liberty of a man. Therefore, despite the fact that right to property as a fundamental right has been abrogated, it has been repealed. Okay, the right may still be interpreted by the court as an aspect of personal liberty, which is coming under Article 21. Therefore, we can say a law seeking to deprive a person of his personal liberties relating to property must not only be reasonable in nature, but it must also be right, just, and fair. And consequently, it must provide for what? It must provide for what type of compensation? For just compensation. It must provide for just compensation. Okay. Now, let us come to various kinds of properties. Okay, various kinds of property. Now, property is basically of two categories: corporeal and incorporeal property. Now, as we know that corporeal properties are visible and tangible. Okay, whereas incorporeal property is not visible and tangible. So, moreover, corporeal property is the right of ownership in material things. Corporeal property is nothing but it is the right of ownership in material things, whereas incorporeal property is an incorporeal right in rem. Okay. Now, corporeal property, it is further categorized into movable and immovable property. Incorporeal property, it is classified into two categories: in re propria and rights in re aliena, or we can say encumbrances. Okay. Now, let us discuss about various kinds of property. The first one is corporeal property and incorporeal property. Okay, corporeal property and incorporeal property. Now, corporeal property is a right of ownership in material things. Corporeal property is the right of ownership in material things, and corporeal property is always visible and tangible. Corporeal property can be perceived by our senses, by our five senses. That is, it can be seen or it can be touched. Now, examples, what are the examples that we can give here? Like a house, bike, land, car, etc. And corporeal property, as we have discussed, may be divided into two classes. movable property, that is chattels, and immovable property. This is the first point. The second point is real property and personal property. Real property and personal property. Then comes incorporeal property. Now, rights in propria over immaterial things. Okay. Now, modern economic developments have made proprietary rights, for example, those of let's say shareholders, holders of bonds, etc., which are not only incorporeal but have no specific material subject matter at all. Very important: patents, copyrights, and commercial goodwill. These things fall under this particular class. Then comes rights in re aliena. Like rights in re aliena or encumbrances are 3 in number: securities, leases, and servitudes. Now, incorporeal property, in a very simple language, incorporeal property also called as intellectual or conventional property. And incorporeal property, it includes all those valuable interests which are protected by law. Incorporeal property is always intangible. It cannot be perceived by our 5 senses. Like, for example, we have already cited some examples like trademarks, copyrights, patents, etc. And incorporeal property is also further divided into 2 classes. Okay. Now, let us come to movable and immovable property. Movable property and immovable property. Now, all corporeal property is either movable or immovable. Now, in English law, these are termed as chattels and land respectively. Now, what are movable property? Okay, let us discuss little bit about the movable property. Movable property is one which can be transferred from one place to another with the human efforts. This is a very simple definition of the term. Movable property is one which can be transferred from one place to another with human efforts. Let's say by your hands, human efforts. Okay, this is an example of human efforts. And what are immovable properties? According to the General Clauses Act of which came in the year 1897, immovable property, it includes land, benefits which are arising out of land, and things which are attached to the earth or permanently fastened, or anything attached to the earth. This is according to General Clauses Act of 1897. I am repeating this again. Immovable property includes what? It includes land, benefits which are arising out of land, and things which are attached to the earth or permanently fastened, or anything attached to the earth. Okay. And then comes Indian Regulation Act. According to Indian Regulation Act, immovable property, it includes land, it includes building, hereditary alliances, rights of way like easement, and lights, ferries, fisheries, or any other benefit to arise out of land, and things which are attached to the earth or permanently fastened to anything attached to the earth, but not standing timber, growing crops, or grass. Now, Section 3, Para 2 of the Transfer of Property Act, which came in the year 1882, it defines immovable property as immovable property does not include standing. So, in a very negative way, this Transfer of Property Act 1882 is defining immovable property. Immovable property, according to this particular act, does not include standing timber. It does not include growing crops, or it does not include grass. And movable property includes corporeal property which is not immovable. Movable property includes corporeal property which is not immovable. Okay. Now, according to Salmond, immovable property, that is land, it is having some essential elements. So, what are those essential elements? The first thing he discusses is that it should have a determinate portion on the surface of the earth. It should have a determinate portion on the surface of the earth. This is according to Salmond. And then the ground beneath the surface down to the center of the earth. the ground beneath the surface down to the center of the earth. Then the third point he discussed, the column of space above the surface ad infinitum. Ad infinitum means infinity, up to infinity. And all objects which are, this is the second point, all objects which are on or under the surface in its natural state. For example, minerals, natural vegetation, or stones lying loose upon the surface. And the last point Salmond discussed, an object placed by human agency on or under the surface of the land with the intention of permanent and an annexation. For example, house, walls, doors, fences, etc. Okay. Now, let us just make it more simple here. Now, all corporeal property is either movable or immovable, as we know. And in English law, these are termed as chattels and land respectively. Now, as we have discussed, according to Salmond, immovable property, that is land, it is having the following elements. The first point we have discussed was a determinate portion of the earth's surface. The second, the ground beneath the surface down to the center of the earth. Third, the column of space above the surface ad infinitum, that is up to infinity. Fourth, all objects which are on or under the surface in its natural state. Example, minerals, natural vegetation, or stones lying loose upon the surface. Fifth point, all objects which are placed by human agency on or under the surface of the land with the intention of permanent annexation. Like for example, you can cite the examples of houses, walls, fences, doors, etc. So these become part of the land. These become part of the land and lose their the identity as separate movable chattels. Okay, lose their identity as separate moving chattels. Now, it must, however, be noted that physical attachment without the intent of permanent annexation, it does not make change in the nature of the movable property. Like for example, let's say carpets or ornaments which are nailed to the floor or wall of a house, or let's say money buried in the ground, are as much a chattel, that is movable property, as money in the owner's pocket. Okay. Now, movable property on the other hand may be defined as any corporeal property which is not immovable property. Okay. Now let us come to real and personal property. Real, we have discussed movable and immovable property. Now let us come to real and personal property. Now, the distinction between real and personal property, it is closely connected. It is closely connected with, but not identical with, the distinction between movable and immovable property. Now, this distinction, however, has no scientific basis. It is mostly the product of the history of the law of action in England. Now, real property, it means what? It means all rights over land recognized by law. And personal property, on the other hand, it means all proprietary rights, whether they are rights in rem or rights in personam. Now, commenting on this distinction, Salmond, he observed, the law of real property is almost equivalent to the law of land, while the law of personal property is almost identical with the law of movables. Now, this distinction between real and personal property has been drawn from the Roman law. The real property and immovable property form intersecting circles which are very nearly, though not quite, coincident. Okay. Now, if we simplify real and personal property, in English law, the property has been divided into the real and personal property. We have already discussed. And this division is identical to a great extent with that of immovable or movable properties. Now, this division, the division into real and personal, it is not based on any logical principle, we can say, but it is a result of the legal we can say of the course of legal development in England. Okay. It is a result of the course of legal development in England. Now, what is a real property? The real property, it includes all rights over land with such additions and exceptions as the law has deemed fit. And personal property, the law of personal property, it includes all other proprietary rights, whether they are in rem or in personam. Okay? So, real property, it means what? Real property means all rights over land recognized by law. If you simplify it, real property means all rights over land recognized by law, and personal property means what? Personal property means all other proprietary rights, whether they are right in rem or right in personam. Personal property means all other proprietary rights, whether they are right in rem or right in personam. Right against the whole world or right against a particular person. Okay. Now let us come to the next point here. Public property and private property. Okay. Now if you simplify it, public property, it is owned by the public as such in some governmental capacity. Public property is owned by the public as such in some governmental capacity. In other words, it is owned by the government and used for the beneficial use of public in general. Like for example, a park or a government hospital, let's say, is a public property. It is a public property. Okay. Then let us come to private property. The private property is that which is owned by an individual or some other person. The private property is that which is owned by an individual or some other person. Now if you simplify it, private property is that property which is owned by a particular individual or some other private person. Like for example, a residential house of a citizen, maybe his private property. Okay, so these are some of the examples of private property and public property. So when it comes to kinds of properties, we have discussed corporeal and incorporeal property. Then we have discussed movable property and immovable property. Then the third point, real and personal property. And then the last point we have discussed, public property and private property. In the next lecture, we will cover various modes of acquisition of property. Thank you.